So for example, if you're doing a high velocity trading system for a financial institution, and that every millisecond counts when in terms of executing a trade, then you don't want to have latency, which can occur when the data center is a long way away.
So for both OESs and DSPs, they're required to implement appropriate and proportionate technical and organizational measures to manage the risks posed to the security of the network and information systems on which their essential service relies.
Is IP key to this arrangement? And can you identify and adequately define and describe what that relevant IP is? So if you are developing software or someone is developing software for you, then IP is going to be key to the arrangement, as Martin said.
And when you think about internet regulation, we're talking here particularly about internet access services. So the pipes, the infrastructure and the retail of them. But UK internet law doesn't really regulate the internet itself.
The Act distinguishes between, first, prohibited AI systems, second, high-risk AI systems, third, general-purpose AI systems, or as you might have heard them being called, GPI.
You need to understand what data you're processing, where you're processing it, and how secure it will be. So if you're sending data to a vendor in another country and it doesn't have an adequate level of protection, then you'll need additional contract terms.
So we talked about having a perpetual term of the software license agreement. You may not want a software support agreement that goes on forever. You may want the right to sort of terminate after a certain period, because you may want another third party to support the software, not necessarily a software supplier.
Where there is a failure to inform and consult, a tribunal can issue a protected award, which is a punitive sanction, and it's up to 13 weeks pay per employee. So that's quite a big deal, particularly if you're dealing with a transfer where there are a significant number of employees that are in scope.
If you have set out an alleged breach of the statement of work, but you get your independent expert involved and they say that in fact that's actually not a very viable point, there's this other point that you could be running, you don't want to have to row back on that in correspondence. And that can be another way of crafting together a good case and hopefully mitigating this dispute, and because you put your best case forward so the other side can respond to that rather than wasting time on weaker points.
And whilst there's plenty of pre-market engagement before 2015, what the 2015 regulations specifically allowed and specifically expressly set out conditions for pre-market engagement to be carried out.
When we enter a particular conversation, we have an agenda. We have things we want to cover, we want things that we want to achieve. It's very high on our mind. And that is a problem, because most people listen with intent to do not listen with intent to understand. Most people listen with the intent to reply.